Hey there, welcome back to another video in this series. In this session, we will discuss various use cases pertaining to the licensing provisions of the Patents Act. Let's start by visiting one of the most basic questions that can be asked on CL. It says, what are the grounds to make an application for grant of compulsory license on a patent under section 84.1? So they are not even giving you a use case. They are directly asking you to test your knowledge, that give them the grounds which can be used to apply for a CL. As you read through the relevant sections 84 onwards or go through the videos on this channel, you will understand the grounds which are required and what are the parameters that the controller look into from the applicant's point of view, from the grounds point of view, and from the technology point of view before granting a CL or while evaluating the application for CL. Let's look into another use case. This talks about what are the restrictive conditions that needs to be avoided in the preparation of a contract or license related to the patent, and what are the consequences of such conditions. So previous one talked about compulsory license. This talks about any license which is there with regards to a patent in force. So you can have agreements, you can have business contracts, all good. But then what are the conditions which should not be form part of a license agreement? So section 140 deals about few of these conditions that you can go through. Again, the video is available on this channel for you to quickly revise it. And what happens when such conditions are there. Let's move to the next use case. A patent is granted to Greedy Limited for manufacture of a product X in the year 2003. The patentee, in order to extract maximum benefit, inflates the price and supplies the product in the market in a limited quantity. Being disturbed by the unjust exploitation of the patent, your client, Right Limited, who is interested to make and market that product, approaches you. What provisions of the Patents Act would you suggest to them under which they can get a license? Advise your client the necessary procedure to be carried out with the patent office. See, if you read the question is framed in a manner for you to understand the situations or the grounds which are there and what provisions you can invoke to go for a compulsory license. So here it says, maximum benefit, inflating the price, supplying the product in limited quantity, ground 2, right? Now, being disturbed by the unjust, Mr. Right, who is interested in make and market the product. So all the conditions are meeting for Mr. Right to approach controller under section 84 to apply for a CL, right? Now, one detail that might be missing here is how many years have lapsed since the patent was granted for you to apply CL. So by now you must have observed that there is a way in which we are reading the question to understand the objective. So as to say, to decode the question. So putting it in a proper method, how do we decode the question? We understand the situation to see if it involves working of the invention is not worked in India, availability of the patented product at reasonable cost and to meet the reasonable requirement of the public. Is this with regards to the licensing terms? Remember the previous use case where the licensing terms should not include some restrictive conditions, right? Or export of pharma product to, let's say, some least developing country which is facing some issues because of which the client wishes to manufacture the product and export the product to another country. Understand the question to see if these are there. Along with this, try to gather details about reasons for the situations along with the timeline. And then finally realize what is the objective of your client. It could be a competitor, it could be a consumer, or it could be a licensee who already has a license from the patent. So with this information in hand, we can start coding our answer. And now, like we always do, we start with mentioning our understanding of the situation. So how do we do so? Here it is. As per the information disclosed, the reasonable requirement of the public is not met, or as per the information disclosed, the invention hasn't been worked in India, therefore it requires CL or revocation of the patent. As per the information disclosed, the patentee has imposed terms which could be considered as unreasonable and unfair. Therefore, the client wishes to one of the objectives that you identified as situation or the grounds which are there. With this, you also mention the section number that you will base your advice on, like this. As we know, section 84 or section 85 or section 92A of the Patent Act provides a provision for what is the objective that you wanted to go for. Therefore, the client can approach the controller court as per the section, again, whichever section that you are talking about. So while you start your response like this, you continue describing the process as per the section that you have identified, any one of these sections based on what exactly you are going about. Now you should talk about forms, timelines, fees, ground for the application that you have made, what are the supporting details documents that you have. I would urge you to make a flow chart for section 84 and 87. In fact, that should be your homework. You should create the flow chart on your own so that you know what are the timelines, what are the grounds, and what are the steps and how the process flows at the patent office. It will help you to recall the process and the procedure immediately, and you can use that while responding to the question. Now we have come to that stage where we need to apply the knowledge on a few use cases. Shall we? Here's the first one. Your client informs you that a patented article is now of high demand in the market. Underline that. From reliable sources, he has learned that the manufacturer of the article might be creating artificial crisis. Underline that. By overquoting the prices. Artificial crisis because of the overquoting of the price. He also informs you that he is capable of manufacturing the said article and will be able to sell at a lower price. So this is why this information is provided, because the controller looks into the ability and capability of the applicant also. That's why this information is provided. Your client is also very much eager to start manufacturing the same immediately. So I can do it right away. So what course of action you will suggest to your client so that his wish may be fulfilled? So mention your understanding that the reasonable requirement of the patented article is not fulfilled because of this. And I wish to apply for CL, and I have the capability and ability to manufacture the article and fulfill the needs of the market. Section 84, you go along with that and describe the flow chart. Yep. Moving to the next one. It says, due to malnutrition, lots of people in Lubang, a least developing country, LDC, are suffering from TB. Lubang has no manufacturing capacity for the manufacturing of a drug. Very effective and cheap for the treatment of DB. So the country is LDC, doesn't have any manufacturing capacity, but is in need of this drug. So the country authorizes by notification a company called Cipla in India to manufacture and export the said pharmaceutical compound to Lubang. Cipla informs that the drug is patent protected in India by LISA and therefore unable to manufacture and export due to fear of possible infringement. Advise your client Cipla about various relevant provisions available under the Patents Act. Now here they have weaved a nice story about a need of a drug in another country which doesn't have the patent or manufacturing capacity. So the drug is patented in India and there is enough manufacturing capacity in India for Cipla to produce the drug. But Cipla is not able to do it because of the patent held by LISA. So what do you do? So section 92A clearly talks about the grounds which can be used by Cipla to manufacture the drug solely for the purpose of exporting to another country. If you read through section 92A, of course, the videos are available also. You will be able to respond to this question by quoting section 92A and describing the process, including the grounds which are there and the conditions which are satisfied, which are provided in this question. For example, notification issued by the country is one such condition, which can be used by CIPLA for applying for CL only for the purpose of manufacturing and exporting. Let's get going to the next one. Motu wishes to license Chotu's patent relating to a slimming device. Chotu is already selling the product in India by itself and through various other licensees. Motu hopes to manufacture the same device and sell in remote parts of India. He approaches you to find out if he should go ahead with the licensing deal. What are the aspects you should look into in order to protect your client's interest, including ensuring that the Chotu's patent is a good one and that he has complied with all the requirements under the Patents Act? Now, this question can be answered in multiple ways. So multiple options can be provided. First is, let's say they are directly going in pure play business deal. So before that, what they need to do is we need to see if Chotu's patent is good enough in terms of whether it is a valid patent. Is there a prior art available that can invalidate Chotu's patent? You can do that kind of a testing first. Second, if Chotu's patent is maintained in order at the patent office, all the requirements are met, maintenance fee is paid, in general is in compliance with the Patents Act. Another one is compulsory licensing option. Because they specifically talked about remote parts of India, can we create a situation or can we evaluate a ground to see if the requirement of the remote parts of India are met or not? If those are not met, it could be a ground for applying for compulsory license. And when you apply for a compulsory license, of course, you can get a better deal as against what you could based on a pure play business deals in license. So these are the two ways you can address this situation. Now there is another question that they say, if a license is finally taken, what are the various requirements under the Patents Act that Motu must comply with? So one of the requirements that is there is, so all such licenses should be recorded with the patent office, and also Motu is required to provide the details regarding working of invention in India every year to the patent office. So this is how you can approach this question from business point of view, from compulsory licensing point of view. Moving on to the last one. Y owns an Indian patent. X requests for a license under the patent from Y. Y imposes certain conditions such that X cannot acquire such articles which are not covered by the patent from any other person. Underline this. Y also imposes a condition of exclusive grant back. Underline this. As an agent, do you think these conditions are appropriate? Section 140 clearly identifies these two as the conditions which should not be included in any licensing terms. So you could provide your advice to X talking about section 140 and how these are restrictive conditions which should not make part of any license, and what options do you have, how you can negotiate your way out of these license conditions. So with this, we have gone over various use cases regarding licensing provisions of the Patents Act. I hope our discussion around the use cases and our approach to decode the question and to code the answer would have given you some thought process, would have given you some skeleton or model to frame your own answers for use cases around licensing. So this brings us to the end of this session. In the next video, we will discuss various use cases around the anticipation provisions of the Patents Act. Till then, be good and take care.